in my petition.
Definitely, acts of terrorism very negatively impact on human rights. They impact on the right to life, they impact negatively on the right to liberty and dignity. And please, Your Lordship, we know that terrorism is a fight, is a vice that definitely needs to be fought. So we want to disabuse the notion, the misguided notion, that we do not support the fight against terrorism. The Commission definitely supports the right to all Kenyans to live safely. There is no conflict between human rights and security.
It is not conceivable today to talk about national security without talking about human rights. That is because the approach of the world today towards security is in respect of what is today called human security. This court will begin to understand why the Constitution says that you must have a mind at human rights whenever you're dealing with national security.
My Lords, we submit that the National Assembly can make positive steps to ensure that Kenyans are able to access and interrogate the law. On our part as a National Commission, we found it very hard to access the first bill that was published on the 8th. We actually got it on the 10th at night. So we wonder, where would other Kenyans be in this?
Public participation is important in the context of this constitution, in that previously we had situations where the Kenyan Parliament in an afternoon changed Kenya from a one-party state, from a multi-party state de jure to a one-party state. And the people of Kenya had nothing to do with it. They went to Parliament and changed it. On another day they went and removed the security or tenure of judges, of the Attorney General, of the Controller and Auditor General, as a Parliament. And that became part of the constitutional law of Kenya, and the people of Kenya had nothing to do with it. So in order to address this mischief, Kenyans have stated in the constitution that they are enacting this constitution for themselves, and where they are giving authority or powers or functions to an organ of state is limited to the extent granted in the constitution. And therefore, my lords, we should take this seriously, because when you talk about public participation, it is an important component of what Kenyans are reserved to themselves. Because the Constitution says the people of Kenya may exercise their sovereign power either directly or through their democratically elected representatives. Why they do that directly is not just election. It's through public participation that they are involved in legislation. They are not just passengers during that process of legislation.
And what has been argued here, that there is no meaningful engagement of the public. It's been argued that there was not enough time for people to travel from far, etc., etc., etc. It was no longer business as usual. Action had to be taken. These laws had to be passed and had to be passed quick. The security architecture had to be changed to make it responsive to terrorist attacks, to defend the lives of Kenyans, especially, and this survey I did not point out, my lords, especially over the December period when most terrorist attacks statistically take place.
We ask the state to tell us how these laws would make them actually apprehend criminals. How would holding someone for a longer period facilitate arrest and conviction and reduction of terror?
And my learned senior Mr. Haminwa, Dr. Haminwa and Mr. Orengo would say that in all the days they fought for liberation of this country, when they were incarcerated in Communicado, there was always a provision of the law that was cited against them, my lord. These are the kind of provisions which are coming back again, my lord, when we thought that we had buried these provisions. My lord, they still seem to be running us from their grave, my lord. I urge your lordship to strike down this article, my lord, and let's live in a free and democratic society.
But Section 31 of the Evidence Act, which is amended by Section 78A of the impugned law, was not suspended. And that section permits the court to admit electronic evidence, even of a secondary nature. So that notwithstanding our objection to that section, the respondents, and particularly the Attorney General, cannot on the one hand come to argue that we are supporting these laws, but on the other hand, in same weight, say we object to the production of this secondary electronic evidence. It is an oxymoron. It's self-inherently contradictory.
There is a lot of instances in this act where the right to freedom of movement, Article 39, is limited. But then the question that the court has to start with when dealing with 24C is, what is the core of that right? When they say a refugee has a right to movement, because a refugee has a right to movement under the Constitution, what is the core? When you say in the Act that refugee can only reside in a certain place and they can't even leave without the permission, is the core being attacked? What is the core, again, just to illustrate, of the right guaranteed under Article 29B, not to be detained without trial? And what happens with that provision of the Act, which now allows the police to bring somebody to court without having to be charged and say, we want to keep this person? Does it derogate from the court? Part of the mandate of the Attorney General is public interest. Really. The Attorney General wants to tell us that a law that has passed in this manner.
That clause 3 be deleted. I put a question that clause 3 be deleted. Will as many as of that opinion say aye? As many as of a contrary opinion say nay? The ayes have it.
Is protecting public interest.
My lord, I wish to point out further that the right to a fair trial is one of the non-derogable rights. Otherwise put, it's one of the absolute rights under our Constitution, saved by Article 25 of the Constitution. What I wish to point out clearly, which did not come out clearly with my learned senior, is that all those rights which have been saved under Article 25 of the Constitution are absolute rights. And therefore, Article 24 of the Constitution that provides for guidelines and instances when human rights and fundamental freedoms can be limited, cannot apply to the rights saved by Article 25. They are absolute, my lord.
My freedom of expression might offend others. That's why we have hate laws. My freedom of expression cannot go against the sentiments of others. Ethnically. Actually, we should say, I have unlimited rights of what I can say, when I can say it, how I can say it. My freedom of movement might infringe on other people's freedom. So there is no such thing as absolute freedoms.
It is my humble submission to your lordship that a compelling case has not been made out at all. A good reason has not been advanced. This was to be done by the Ministry of Internal Security to provide your lordship with details
some kind of statistical information as to why they want this article to be enforced.
The submissions before you have been that, one, we're trying to change the Bill of Rights. Two, we're trying to amend the Constitution by the back door. Nothing can be further from the truth, my lord. We're trying to operate within the dictates of this Constitution.
Here, we would like to point out that this court cannot go into and examine the need of POTA, that is the Prevention of Terrorism Act. It is a matter of policy. Once legislation is passed, as this court has been, once legislation is passed, the government has an obligation to exercise all available options to prevent terrorism within the bounds of the Constitution. The important sentence. Moreover, we would like to point out that this court has repeatedly held that mere possibility of abuse, as is already being urged here, mere possibility of abuse cannot be counted as a ground for denying the vesting of powers or for declaring a statute unconstitutional.
The first point that I want to deal with is in relation to the submission of the DPP, which was about justiciability and rightness of these proceedings. My lords and my ladies, before I go into it, you know, sometimes when we speak as lawyers and we read from the Constitution and try to interpret the Constitution, we wonder whether we are reading the same document. And I sit here, I'm beginning to understand why, although we are promulgating or pronouncing from the Constitution that the Constitution is supreme, yet in this Constitution, my lord, you find the provision in Article 3 which talks about the duty of every person, rather obligation, to respect, uphold, and defend the Constitution. And my emphasis is not the word defend the Constitution. That we should not be a nation living in fear, and also fear from those who govern us.
The question as to whether the prosecution is entitled to delay disclosure, the question as to whether written statements should be admitted, the question whether agreed facts should be admitted, admissibility of evidence, and so on and so forth, are matters that, my lord, should be raised and therefore are not appropriately. A lot of what you heard in the last few days was how this legislation is imprecise, how it is ambiguous, and so on and so forth. That is not, and there is no statute, my lord, that is perfect in terms of its language. It is the business of the court dealing with that particular provision to interpret the legislation.
Milad, I pose a question to you. Does this court believe that we should publish images of dead and injured persons which are likely to cause fear and alarm to the general public? Simple question. But an accident occurred tomorrow and we'll see all their bodies splashed in the newspaper. Do we want, as a nation, to be subjected to this? That is a question that must be asked. Second question. Information which undermines investigation. Do you want it published? Do you want an investigation undermined? Do we want information that undermines a security operation? Like happened in Westgate. In fact, Westgate was an interesting case where they were streaming what was going on in Westgate. And they were communicating on phones to the people inside so they could take time and go and pray because they knew no one was coming. They knew exactly where the security operation was when it was being conducted. Is this what we want? So,
my lord, on that point, you are referred to a number of regulations in the Code of Conduct for journalists. And I think by Ms. Mwangi, Volume 1D. And the submission was this: we already have sufficient provisions in the Code of Conduct, in the Media Council Act, is Media Council Act, that deal precisely with the subject of Section 12 and Section 64. And the question then was asked, what is the necessity for these new provisions? Now, first question to ask, my lord. If then it is the argument that these provisions in the new Act, Impugn Act, are unconstitutional, how is it that then the regulations, which are subsidiary legislation, covering the same subject matter, have not been impugned?
I'm grateful to the Ghana DPP for saying that these proceedings are anchored on fear. And I think that this country, we want to live without fear.
But your lordship, I fervently invite this court, quoting the words of an eminent publicist, to seize the entire Security Laws Amendment Act, your lordships, and throw them into the River Tana, heavily weighted with thinkers, to prevent them from ever rising again. That is all. Thank you for the
Thank you.